Okay, so let's talk about the history and development of copyright now, okay? Now, the history and development of copyright can be traced back to about 16th century England, beginning with the first so-called Licensing Act by the English Crown in 1534. Now, though the act was not a code of copyright protection, not necessarily a copyright law, right, per se, but a requirement by the Crown to license all the printed publications, it eventually led to the development of the first copyright statute, the Statute of Anne in 1710, and we'll talk about it a little later. See, the United States' first copyright law was based on this statute and was enacted by Congress in 1790, and subsequently, throughout the following more than 200 years, the United States Copyright Act underwent a number of revisions, which shaped it into what it is today. Now, though the direct roots of the copyright law are found in 16th to 18th century England, the history of the copyright notions can actually be traced back to ancient Greek and Roman cultures, where the government sponsored and supported the arts and the creative output of various authors and artists. Now, the government, nobility, and church sponsorship of the arts remained the prevalent model of supporting the arts and the artists, and one of the few ways that artists and authors could even earn a living throughout much of European history until the development of the first copyright law in England in 1710. During the 16th and 17th century, the English publishing industry adapted this practice of a full transfer of ownership from an author to a printer publisher in exchange for a single fee or a single sales price, right? In other words, the author would sell his work to the publisher for a certain price, and from that point on, the publisher would assume the full authorship and control of the work. In addition, starting in 1534, in order to prevent possible religious heresy or political dissent, the Crown required that all the books to be published must be licensed by the Crown prior to the publication, and we refer to this as a licensing act. Okay, now, also, the Crown granted exclusive printing and publishing privileges called the royal patent for the particular kinds of material to certain individuals. Well, now, one of the first significant royal patents for music was granted in 1575 by Queen Elizabeth I to her main court composers and musicians, Thomas Tallis and William Byrd. Now, in gratefulness for their service, the Queen stipulated in a sweeping patent that Tallis and Byrd were the only individuals allowed to produce, sell, and trade printed music paper, and the only individuals authorized by the Crown to print and publish, listen, music of any kind in any language throughout England for the period of 21 years. Now, that's not exactly stimulating for the music publishing trade, diversity, and competition, as it created really a business monopoly vested in these two individuals. Now, you'll watch the video about Tallis and Byrd. If you go to the material notes and you go to part 4 or module 1 of the material notes, you'll see that I put a link there to watch the video about Tallis and Byrd and a little bit more about them. Now, after the expiration of this Tallis-Byrd patent, this tradition of granting royal music printing privileges continued, though with much less scope and shorter duration, until about mid-18th century. The scope of the subsequent royal music patents was most often confined to the music written by the patented composers or to the particular kind of music, and was generally limited to only 14 years. Now, the printing and publishing of regular books at the time was a different issue and was regulated separately from music publications until mid to late 1700s. See, the exclusive book printing and publishing privileges and powers held since 1557 by the London's Company of Stationers, a book publishing guild, ended in 1695 when the Parliament refused to renew the privilege and instead started working on the first Copyright Act. This act, named after Queen Anne, the Statute of Anne, was completed in 1709 and was in force in 1710. You will read more about Statute of Anne and see the original document and so forth. When you go to your material notes, there is a link there. Okay, about that. This statute gave to the book authors, for the first time in history, the exclusive rights to printing and publishing of their work. The duration of this first historical copyright was 14 years, with the possibility of renewal for another 14 years. But how about music? Was printed music a book? Is it protected by the copyright like all the other books? Well, for a few decades after the statute was enacted, it wasn't. Royal privileges were still served as the only type of copyright protection for music, but due to a number of music publishing litigations and court decisions regarding this issue, the copyright law was steadily being applied to music publications in the mid to late 1700s, the legal development of which has greatly influenced and boosted the music printing and publishing industry, setting it on a path that led to its today shape and form. Now, the development of the first copyright law and the growth of the music publishing business throughout this time is the very root and the cause of music creators becoming self-sufficient, generating their sustaining income in the marketplace, and not being exclusively dependent on support and sponsorship by the nobility and the upper classes, as it was the case until this time. It is the composer's declaration of independence, the big bang of the music business universe, the birthplace of the music industry itself. See, together with the printing and publishing trade, the copyright ideas traveled across the ocean with the first American settlers from England, and the regulations of the Queen of Anne's 1710 statute on copyright found its way into the United States Constitution in 1790, including its 14-year-long term of the copyright protection. Again, you will read a little more about United States Constitution, see the original document. You'll have the link there in the material and notes for Module 1. Now, the basis for the United States Copyright Act is the United States Constitution, which in Article 1, Section 8 states, Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. In other words, the Congress has the power to design and enact the laws regarding rights in artistic and scientific work, generally known as intellectual property, as the name of this course. The first such legal code in the United States, the Copyright Act, was enacted by Congress in 1790 with a number of revisions to follow throughout its over 200-year-old history. Now, in terms of provisions changing and evolving, yes, its terms and provisions are crucial for the music business industry and have shaped many of its components, methods, and practices. Now, as in the statute of Queen Anne, the United States original copyright law did not mention music, though. But just like was the case in England, the power and the reach of music composing, printing, and commerce asserted itself into the law, and the United States legal code eventually recognized music as legitimately copyrightable work in 1831, bringing its copyright owners all the relevant rights and privileges. And you'll watch the video about the history of the copyright law in the material and notes for Module 1. There is a link there for that. Now, actually, that was all the relevant rights and privileges regarding music printing and publishing, but what of the rights for the countless public performances of the musical works? These rights didn't become part of the copyright law in the United States until 1856, when they were applied only to the so-called dramatic musical performances like operas and operettas of the time. It wasn't until 1897 that all the musical works were protected by the public performance rights in the United States. In addition, the 1909 revision of the Copyright Act extended the music copyright further and included a requirement to obtain a statutory license from the copyright owner in order to create a sound recording of the copyrighted musical composition. And we call this, even today, mechanical license, meaning that if I want to record your composition, I need to obtain mechanical license from you. This particular requirement became part of the Copyright Act in 1909, okay? Now, the sound recording itself, see, now that I create the sound recording, do I have any rights about sound recording? Well, the sound recording themselves were not protected by the Copyright Act until the amendment to the Copyright Act in 1972, when they were granted first limited rights, which notably did not include public performance rights. What does that mean? Well, in 1972, when the sound recordings became copyrightable, meaning you could own the copyright in the sound recording itself if you have recorded it, right? That right did not extend to the public performance of it, meaning that anybody can take it and actually play it somewhere, like in a bar or on a radio or something. So, and by the way, we still don't have those rights. I mean, it is the composer who gets paid for his song being played on the radio, not the performer who recorded a song. We'll talk more about that. Don't get confused. Anyway, 1909, we're extending the copyrights to a sound recording, but we are limiting it to everything but public performance of it. Now, the most comprehensive revision of the United States Copyright Act came in 1976, and that particular revision became effective in 1978, and most of it is still in force today. Okay.